Mike Rabel.
Hi.
H is silent.
That's right. I'm Mike Rabel. It's not pronounced the way it looks. The H is silent. My father was a Goldwater Republican who gave me two things. One, he gave me a difficult to pronounce last name, and the other was he instilled in me conservative values. Goldwater was the man before Reagan who told us things about limited government, balancing the budget, beliefs that I continue to hold dear. He also was very strong on states' rights and other constitutional principles that we have pretty much abandoned in this country over the past 30 years, and then that makes me sad. There are three reasons that you should vote for me, and there are three reasons that I am different and more qualified than the other people on this, and Chip's wife, the other three people on the dais. First is I have been active in the Republican Party. I'm the only candidate that has voted in every Republican primary and runoff in the last 12 years. I have not missed one. I've been a delegate to various Senate district conventions. I've been an election clerk. I've licked and stamped envelopes. I've put out signs. I've helped candidates. I've done the grunt work. I don't have any glorious titles, but I did the stuff down in the trenches. Secondly is education. I graduated fourth in my class from Texas Tech Law School. I was a magna cum laude graduate. I was a research editor on the Law Review. And I've continued my pursuit of academic excellence. I'm one of the 6% of Texas lawyers that's a member of the College of the State Bar of Texas, which means I take twice as much continuing legal education as that required just to maintain your license. Finally, I'm the only candidate in this race who's a member of the, who's been board certified. As Barkus Hunter talked about, board certification, it's a rigorous process. It requires you to try, not just be involved with cases, but to actually try cases from the beginning to a verdict. Then, after you've done that, you're peer reviewed. The lawyers you tried them against and the judges you tried them before must look and say, yes, this person did an exemplary job. If you pass those hurdles, and not everyone does, you get to go to Austin and sit for a 6-hour exam, which is much like the bar exam, which after you leave the bar you say, I'll never take another test, but you actually sometimes decide to. I did it twice, and I did them back to back. Those three reasons set me apart, and I believe should earn me your support. Thank you.
And fourth on the ballot, we have Wayne Birdwell. I might mention to all of you, you might adjust this up and down as you go. I'm shorter than most of you.
I'm Wade Birdwell. I'm also running for the 17th District Court here in Tarrant County. And y'all probably have figured this out more than other people in front of whom we talk, and that is that trial courts matter. Because trial courts are generally the ones who do the most interpretation and application of the law. It doesn't often get to the Court of Appeals or the Supreme Court, let alone the United States Supreme Court. And so when you're electing someone to a district court bench, you need to elect someone who has a very good and wide knowledge and experience with the law that they will be applying. Now, Mike's correct, he's board certified in civil trial law. I'm board certified in civil appellate law, and that requires that I go through the same rigorous examination, except in this, instead of being examined by just one attorney against whom I'm going in a trial court and one judge in front of whom I'm going, I'm literally being examined by 3 judges every time I go up in front of the Court of Appeals, and the one time that I've been in front of the Supreme Court, 9 judges. And I'm the only one up here who's actually arguing in front of the Supreme Court of Texas. Although Mike, to his credit, was a briefing attorney, if I remember correctly, so he knew a few things behind that. Judicial philosophy is what matters, and anybody can get up here and tell you that they are, in fact, an originalist or a strict constructionist. The question is, do they have a record of that? And I'm the only person in this race who actually has a record you can go and read. Many of you are studying case books now as students here at Texas Wesleyan. And I've got about 40 opinions that I'm responsible for, some of which I was successful in, some of which I was not. I've been lead appellate counsel in 60 appeals from the 5th Circuit, the Supreme Court of Texas, and several of the courts of appeals, mostly in front of the Fort Worth Court of Appeals. I'm the only one here with decisions dealing with due process, with free exercise, with the actual procedural rules that will be applied by the trial courts, such as jury selection and summary judgments. And for that reason, I think I'm the most qualified to ask for your vote. Thank you.
We'll start with one from the audience. What does it mean to be a conservative, and how have you applied that in the past?
Where do you want to start, Chair?
Why don't we just start at the other end and come back this way?
Okay. Conservative generally means a traditionalist, that you understand that there is a basis for our traditions, and you respect those traditions, and you want to see some evidence that the change that anybody is coming up with regard to changing a particular tradition actually will work. And so from a judicial philosophy standpoint, conservatism is you have an understanding that you are accountable for your decisions, but in truth, that you're there specifically to apply the law, to interpret the law the way it was originally intended to be applied. And if you don't do that, if you amend the law or the Constitution in the guise of interpretation, you are usurping the legislative function, and you are effectively disenfranchising the people with regard to their voting and what their preferences are. You're changing the law without any accountability whatsoever. And so from a judicial philosophy standpoint, conservatism means that you appreciate, you respect, and you apply and interpret the law the way it was originally intended, the way it went through the legislative process where the people had a chance to consent to their government.
I would concur very much so with what Wade just said. I think conservatism is basically, there are two sides of the coin. One is more a political philosophy, that is, we should view government with suspicion. The government was given limited powers in the Constitution, and in fact, I seem to be Clarence Thomas and I seem to be the only two that remember there's a 10th Amendment that says the power is not specifically granted in this document to the state, to the federal government, nor prohibited to the states, belong to the people. And I believe that's what a true conservative is, someone that thinks that people have the ability, the innate right to make decisions on their own, and not to have the government interfere at every step of the way, as they have done. With regard to conservatism in a judicial context, I do believe that one of the things that we are required to do is strike down acts of the legislature when they exceed those boundaries. The boundaries set up in the Constitution, I think, are very clear. I think they've been set up for the protection of individual liberties, and that in order to be a true conservative, you need to adhere by what the original meaning was when the Constitution was drafted. The original people, that the original founding fathers set forth in Federalist Papers and in other writings, even letters amongst themselves, what they considered each of the provisions to mean. So I think it's fairly easy to glean those. And so I think conservatism means not only limited government, balanced budget, like that, but in terms of the judicial interpretation, that we should only step in and intervene when the Constitution has been violated.
I believe, and I'm sure Melody would agree with me, that a conservative judge is one who interprets and applies the law as it is written, regardless of whether he thinks it's a good idea or not, he or she, or regardless of whether she believes that they would have passed the law had they been in the legislature, with the caveat, of course, that if it violates the Constitution, if it is outside the scope of the legislature's powers, then the judge should not and cannot enforce it. And in keeping with your suggestion, I'll give the time back.
Thank you.
Dr.